Well, good afternoon, everybody. I'm John Giardinelli. I've been your association counsel for quite a long time, and the brown bag was initiated at Southwest Riverside County back when you were Rancho Temecula, and we've been doing it ever since. Today we're going to talk about, well, go ahead and advance the screen to the third slide on to these young kids who we're talking about. You guys get some new forms actually going to come out the week of December 19th. I don't know exactly which day, but probably early in the week is what I've been told. So sometime during the week of the 19th, all of the forms that we're talking about today will be available to you live in their final format, no longer draft. We're on the same day, we're going to be talking about something that's important regarding making sure you get paid. And they're going to be updating the procuring cause guidelines. And I will explain all that to you. I was on a program yesterday with Ed Zorn, who, as you know or should know, is the attorney for your multiple listing service. He gave us some updates, and I'm going to share that with you. Most of it's going to be on your PowerPoint, but there's been some updates on the updates. So just so you know what's going on, I'm going to give you some standards of professional standards changes, because that goes to your code of ethics. There are not very many, but I want you to be aware of them so you don't get in trouble next year. We've had some issues with the Americans with Disability Act lately, all across Southern California primarily. So I want to kind of give you guys a brief update on that. Next slide, please. We're going to talk about a couple of new laws that are going into effect, some new cases that have come down. Courts are open again. And then yesterday we spent could you please mute yourself so that if you got to talk to somebody else, please do that.
All right. I'm going to remove my webinar. So.
Yeah, whoever that was, there's a gentleman who's talking who's not muted, and I would appreciate it. And so there's some liability issues that are coming down. And one of the people on the panel yesterday actually is an attorney that specializes in insurance defense work. And so between he and I, we've been seeing some trends lately that I want to share with you. And then if we have time, we'll talk about some property management issues, but probably going to have to defer that to another time. We'll also take your questions. If you want to ask a question about any topic, whether it's on the agenda today or not, put it in the chat room and I'll do my best to get to every question before we leave and answer it. Once I'm done with you guys, I'm off for the weekend. So I'm 2 hours ahead of you. So I'm happy to stick around a little while longer than we've originally anticipated. Okay, so going to the first, I broke up the new forms. There's going to be about 10 new forms. And I broke them up into buyer representation type forms, and then we'll talk about the other new forms in a separate grouping. So clearly and I'm going to pull it out, my particular form, but clearly the most important new form is actually the consolidation of 3 of the forms you are currently using. It is the buyer representation and a broker compensation agreement, which is a consolidation of the 3 buyer representation agreements that exist today. Now, a couple of things. There was a lot of talk about making broker compensation and representation agreements mandatory by legislation. That is not being done at this time, so it is still voluntary. But everybody on the panel yesterday, a broker who was actually part of the broker task force that ended up coming up with most of this stuff. All 3 attorneys all agreed that while it may not be legally mandatory, we all believe, number one, that it should be mandatory, but that if you don't have a buyer broker representation agreement, there's a lot of bad issues that could come your way. So I'm not going to lecture that today. I'll do that at another time. But here's the deal. So this is the form. It is meant to allow you to choose, again, a couple of different options. So first of all, paragraph 3 is the property. Now, you can do it in one of 3 ways. If you are working with a specific buyer on a specific piece of property, then you fill in the information under A.
And once you register, then the link we gave.
If you are going to look at several properties, then you can check off B, and you can attach whatever you need to attach. And of course, if you're going to be working on multiple properties, I'm going to show you a form. And could you people, whoever is not muted, please mute yourself, because it's distracting. Then what this agreement does is it talks about compensation. You know, are you going to be given a compensation under which circumstance? Is it going to be because you're involved in an exclusive, and I basically now have an exclusive right to represent these buyers for a particular period of time? Is it going to be properties that I was, quote, involved with? And that means properties, and again, if you look at this form and read it, you will see that, you know, did you enter the property? Did you provide information? There's a list of things. There's 4 items there that define what it is to be part of a broker involved property. And there is a form that's coming out on the 19th for that. And again, is it going to be exclusive? If it's going to be, I don't know, I'm not controlling that, Barbara. All of these forms, by the way, are available for just review right now, not for use, because it'll say the draft watermark on the CAR site. You can download them at your leisure. There is also now, instead of them just walking away from you, if you have this agreement, there is a specific paragraph for, no, don't change yet, there's a specific paragraph for, yeah, I guess Christine mentioned you can zoom in. I don't know how you do that. I'm not gonna deal with that. But so that you can cancel, and there is a cancellation of this agreement, which is different, but set up similar to the cancellation of contract that you guys have been using for a number of years. There is an ability for you to account for the payments that are due you, for whether it's going to be, you've agreed that you're going to get back your some type of expenses or whatever it might be. And then there's some additional rights set forth. There's a disclosure of anticipated payments to broker by others. In other words, if you're being paid in the traditional way, let's say, for example, you're paid by the listing agent directly through escrow, through the offer of compensation, well, then that's 100% credit, and the buyer will owe you nothing. Now we can go to the next page, please. There are issues of timing, payment through escrow, a representation that the buyer does not have any pre-existing agreements with anyone else. There is broker authorizations. And again, as you go through this, there's also a whole list of buyer obligations. There are a good faith and that they're going to be truthful with you, and all those kinds of things are in section 7. Next slide, please. There's a dispute resolution. There are going to be, with this form, bundled a new buyer transactional advisory form, which I'll show you in a second, and the property representation agreement, and the representation of more than one buyer and seller. I also would suggest to you that you give them at this time your agency disclosure form, because if there's a dispute and you don't have an agency disclosure form, you're going to have much more difficult time. So, and then at the end of the day, you have an entire, what we call an integration agreement, that everything you guys have agreed to is in this contract. So you could put things under other terms or attach an amendment. And then, of course, you have a place for signatures, which has also been set up if you're representing a trust or a corporation or some other type of entity. So let me just talk about this form before we go. Well, go to the next. Let me see which one it is. I can't remember off the top of my head which order I put these in. Okay. This is an addendum to this contract that I just showed you. And this is if you're only going to represent one property. Okay. So this is for representation of one particular property. Now, a couple of things. Again, Article 9 of the Code of Ethics, this is the conversation that took place yesterday. I want you guys to understand. I wish I could see y'all, but I can't. So I have to do the best I can. I'm talking to a screen here, but I'll make believe that I'm talking to staff. How's that? So here's the bottom line. You guys all have agreed to the Code of Ethics. Code of Ethics under Article 9 specifically says that you're to put every agreement that the client agrees to in writing and provide them with a copy as soon as practical of what they've signed or initialed. So how do you get around not having a buyer representation agreement? And the argument we hear, and we hear it all the time, and it's nonsense, is that, well, if I ask them to sign it, they won't want to sign it, and they're going to go somewhere else. Two things on that. First of all, how are you presenting it to the client? I know that when I've purchased a number of properties here in Tennessee because I sold property that I owned in California. And before they would pick up anything and do anything with me, I signed a buyer representation agreement. It was the common practice in Williamson County where I live. It is what people do. And frankly, it made perfect sense to me because the document spells out what my agreement is. I am getting ready to purchase a very large transaction, right? Probably in most people's cases, the largest of their lives. Why wouldn't I want that in writing, right? You get all kinds of you get an estimate from a car repair company. And number two, if a client doesn't want to sign something confirming that you're entering into a relationship with them, is that client somebody that's going to walk away from you, stiff you, have you show them 30 properties and then go to, Bob Jones, a good buddy of theirs, to get a discount and to do the deal, or maybe even go to the listing agent. So I could give you a lot of other arguments. I'm working with a real estate broker friend of mine, and she and I are writing up a class on broker representation agreements that we'll offer both online and live next year. I just think it's really, really important. Think about it. I'm suing you and I'm arguing. And one of the issues in the case is I'm saying, well, she promised me that she would do certain things. She said that this wasn't going to be, anything that I was going to be charged for. And you don't have anything in writing, and you're a fiduciary to that client. Is it going to be more difficult for you to prove up your case or to prove you didn't do anything wrong? I just really think that this agreement, I wish they would have made it, gone to the legislature and made it mandatory. Let me see if there's anything else I wanted to talk about on this form. Well, we're going to talk about some changes to the RPA, and there's a form I want to show you that you can work with this form for that. Again, take a look very carefully at number 4B, because that talks about what it will take for you to become broker involved. Obviously, if I end up buying a property that you don't show me, forget about it. This has to do with you showing me the property that I've ended up purchasing. I didn't purchase through you. Are you entitled to any money? And I think also the cancellation because it provides for methodologies. You don't just leave the person. So again, I think I've written a bunch of notes. I'm trying to see if there's anything else I wanted to mention here, and there is not. There's an arbitration mediation clause, buyer single agency. So let's talk about the next slide, please. This is a form that's a disclosure. It's not mandatory, but it will give you the ability to be transparent with a client. And I'm going to talk to you about some billion-dollar lawsuits that are pending right now in just a minute. But what you need to understand is that it's not business as usual any longer. The commissions are so large now, in many cases, that the rules are, they want you to be as transparent as possible. And so this form is set up so that you can, as the properties are being shown, you can actually provide the buyer with what your anticipated compensation is and how that might affect the purchase price and other things. So take a look at this form, use it, don't use it. Again, it's a way of the buyer acknowledging, you know, I talked to Lisa, we agreed that this was what she anticipated she was going to make, either because of what was being offered directly by the seller, what was in the multiple listing service, what was in a cooperating broker compensation agreement, however that's going to be structured. Now you got something in writing saying, oh no, we talked about this. There's your signature right there. Next slide, please. I love this form. I love this form, right? I do a lot of defense work, a lot of risk management work for my broker clients. And one of the things that crops up all the time is, you know, what are you going to do for me? What are you not going to do for me? You know, what are my responsibilities? And this form, which is simply an advisory, it's a form you would give with a buyer representation agreement. But even if there is not a buyer representation agreement, you can use this form and look what it does. Paragraph, there's some general topics up at the top. Then we talk about the reasonable care and other professional assistance that the buyer is required to give to you. Have these ready. If you've got a client that you think is serious, give this as early as you possibly can and make sure that they have the ability to read it. Obviously, as I always say, you should read it too. There are issues of agent duties. What are you authorized to do? What's the scope of your duties? If you look at the RPA contract, this is repeated in the RPA contract. You know, things like you don't guarantee or you don't set the price, you don't guarantee boundaries, you don't do a whole bunch of things that the contract also says you don't do. And I think that by giving this to them, along with what's in the RPA, you've doubled down now on the fact, hey, my duties are limited. I don't do, you may think I'm going to go check permits. You may think that I'm going to set the price or that I'm going to guarantee the house, right? You may think I'm going to do that, but now I'm telling you in this document and I'm telling you in the purchase agreement, we're not doing it. It's not our job. You know, if we have special information, we'll give it to you. You have a duty to investigate the property. There's a jury instruction that actually says that. You have a duty to read the contract. It says that in 3 different places in the RPA. And if you look at paragraph 5, it reiterates, you have a duty to read the contract. They're important. If you have questions, we will endeavor to answer them for you, but you've got to read all 16 pages. Lending is complicated, and you need to understand that we'll help you any way we can, but we are not lawyers, and lending needs to be something you need to be familiar with. And then there's a paragraph about the escrow process. It's a one-page form. I would give it to every buyer as early as possible. Make sure they understand. Again, even if you don't use the compensation, the representation and compensation agreement, that this agreement, at least if you've given it to them, if you got it signed and you can put it in your file and it's early enough in the game, is going to give you some cover. Again, yesterday we talked about this with the insurance company attorney, and Steve Spiles, his name. He's a phenomenal lawyer, one of the best I know. Been working with him for 40 years. This is really a good form because, again, when you guys operate, you operate, there's a box of things you should do. And by staying in the box, you give yourself better cover, obviously. And I think that keeping this form as part of the things you give to every prospective purchaser is really going to help you, because it's going to be much more difficult down the road for a buyer to say, well, I didn't know she wasn't going to measure this, or she wasn't going to, do that. Well, wait a minute here. Paragraph 3B clearly limits the scope of what it is that you're going to do, in absence of special knowledge that has to be disclosed to your client. You should be good. Let's go to the next slide, please. This is the cancellation of the buyer representation agreement, and it is set up almost identical to the cancellation of contract that you're currently using, which, by the way, is going to be revised. It's one of the revised forms I'll show you in a minute. But again, it's simply the notice. If you look at the representation agreement, you have to provide a notice that I'm canceling the representation agreement. Either side can do it. And then there is a box. So there's a place for notice of cancellation, some boxes to check off relative to that. There is a box for cancellation within 5 days, or a certain number of days, or immediately. The confirmation that the broker will not be the buyer's agent for any negotiation or transactional work. There's a statement regarding compensation that is due pursuant to that agreement. And then there's a place for the buyer to, a suggestion for the buyer to get information regarding estate, tax, legal, insurance, etc. And then there's a place for signature. Now, if you guys can't agree on compensation, then that's why there's that solid line down the middle. But if you can agree, okay, I don't want you to be my buyer's agent anymore. We've agreed on what I'll pay you to go away, or what you'll agree to pay me what I think I'm entitled to. Then you can fill out number 3, A through E, and get that squared away. Go to the next page, please. And before I do that, wait 1 second. Again, it has to do with acquisition, expenses. Maybe all you're going to ask for is a referral fee. A broker to receive compensation directly from seller. Maybe that's how it's being structured, and there's a form I'm going to show you in a minute. Or you're simply agreeing to go away, releasing the buyer, and you're done with them. Next slide, please. And then, of course, you have a place for the ever lasting other, etc., and then signatures. So again, another form. And I think what you're seeing here is that there will be, over the next year or so, a systemic change in the relationship between buyers and agents. And you're going to see it even further when I get into the MLS stuff. Next slide, please. Okay, this is a great form to protect yourself. It is due within 5 days after you've canceled the agreement. This is the notice that you will provide to a person you've been working with. These are the properties I claim I have had involvement with, and I will claim a commission if you, or a referral fee, or whatever it's going to be, if you buy any of these properties. This is that safe harbor form that is going to make sense. It talks about, it reiterates whatever your compensation agreement was. It reiterates what the representation period was. And then again, it reiterates what it means to have a broker involved property, that you did those things referenced in paragraph 4 before you get to the lines. With these particular properties, you list them by address. And if there are more properties than you can stick in there, there's a box, as you can see in 4 at the bottom. You check off that box and you add an additional list. There's a representation that the buyer should notify the new broker. And I'm going to talk to you about that in a second, because we had a lengthy conversation about that. And we're going to talk about that in just a second. So next slide, please. Now, and I can't remember let me see if I can dig out the exact paragraph while I'm talking to you. So in the Northwest right now, they are experimenting. It's a broker-owned MLS, and so what they've decided to do in light of all these lawsuits is they've modified their rules and their RPA and created some other documents. And on October 1st, they rolled it out where the seller actually negotiates directly with the buyer's broker for payment, because they've taken the offer of compensation out of the MLS. Now, why is that important for California? Both Art Carter, who runs your MLS, and Ed Zorn, who is the attorney for your MLS, both believe that mandatory, don't change yet, please, that mandatory offers of compensation will be leaving the multiple listing service within the next 18 to 24 months. That means that for those of you that have been around for a long time or have been successful or both, are used to the idea of offering, getting a listing agreement for 4.5%, 5%, whatever it is, putting 2.5% in the MLS as an offer of compensation to a procuring buyer, an agent for a buyer. That's probably not going to be the case, at least as a mandatory requirement down the road. They're working on some rules. I'm not going to go over those today, because I don't want to confuse you with what is versus what shall be, but be aware that there's lots and lots. I was on the phone before I came on the phone with a client who's developing a new way of offering compensation. And it's just, I don't know how I can say this other than, for those of you that hate change, I'm sorry, because there's going to be significant change. But my goodness gracious, if you've been a realtor for more than 10 years, you've seen incredible changes. Maybe not, you saw a brand new 16-page RPA last year. You've seen the introduction of everything online. You've gone from books to computers to what you have today. You've seen enormous changes. But because you're past the change now and you're used to it, that's the way you do business. Somebody once said to me that people don't hate change, they hate the process, right? Because you got to get used to a whole new way of doing business. And it's exciting for me as a lawyer, because we're at the forefront. We've got an opportunity to fix some things, a couple of things, just to make sure you don't overreact. I hear all the time, and I've heard it for 20, 30 years since I've been doing this. Oh my God, the banks are going to take over. Oh my God, the virtual office websites are going to take over. Oh my God, the discount brokers. Oh my God, this company or that company are all going to take over. Well, you know what? As of last year, realtors were involved in transactions 90% as opposed to 80% of the transactions 10 years ago. So number one, you're not losing the market. It's just you're going to have to do things differently. For those of you, well, the people that show up, the 145 people that are here today, you're not the problem, right? You take classes like this, you try and get ahead of the curve, and you're going to continue to have to do that. Just like every day I get up and I get to my desk at 6:30 in the morning, 4:30 your time, and I start reading and I keep up, because that's the only way I can stay a professional. And it is the same for you. Number two, for those of you that are entrepreneurial in nature, these aren't problems, these are opportunities, right? You're going to work through the system. You're going to keep in touch with what's going on. You're going to talk to people like myself, like Ed. We're going to do some legal panels next year, and we're going to have these kinds of people come and speak to you. You're going to listen and you're going to ask questions, and then you're going to figure it out for your own company, because these are opportunities. Whenever I see change, and I'm an old dude, but I see change, it's an opportunity to do better. I agree with you, Pauline. Change, you don't grow. Somebody once said to me, we were talking about people going through tough times, that if you've ever been a skier, when you get to the top of the mountain, there's very little vegetation up there, right? The growth all takes place in the valley. And I think what you need to see here is that these are challenges, but there's ways of coming up with business plans that I think are going to be very, very helpful for you. So we're going to talk a little bit more about this. I see I've got a bunch of questions here. So let's go to the next non-buyer representation related forms. Other. We're going to have a rental property owner disclosure. I attended a meeting a couple of weeks ago in LA with June Barlow, who's the attorney for CAR. And at that meeting was Neil Kalin, who is the attorney that does most of your forms. And Neil is telling me that the term landlord, much like the term master bedroom, is going away. And so the new name is going to be RPOs, rental property owners. And this is a form that, as the property manager, you will get from your client. And it is a disclosure. It's not mandatory like a TDS. It's more like a seller property questionnaire. And what it is basically that the RPO is indicating, to the best of their knowledge, all of these things do or do not exist. He's not aware, she's not aware, or they are aware. And as you can see, there's a whole, if you look at paragraph 4, go to the next page, please. Yeah, you're not allowed to take a break. You've got to stay at your desk. As you can see, there's just a whole ton of questions, right? So you're going to get this. And go to the next slide, please. Even more, parking, permits, electric meters, trash pickup, lawn watering. Again, pets. Remember, service animals, companion animals are not pets under the law. But you're gonna have all this, mailboxes, laundry room, appliances. Next slide, please, is one more page. And you're going to then, they're going to give that to you. You're going to acknowledge receipt, and then you'll be able to turn it over to the new tenant so that they have everything that they could have. Because, as you know, in addition to all the other changes, for those of you that do property management in California is no longer what it is in places like Tennessee or other states. It is completely being restructured, and the government has, we've seen what's happened. So again, take a look at it. And like I said, Audra, I'll get to most of these, all of the questions or comments towards the end, but I want to make sure I cover all this. So let's go to the next slide, please. Before, maybe a little late in light of the market, but nevertheless valuable. If you're going to make a non-contingent offer, this is an advisory you can provide to your client that gives it. Basically, it's a form that they took their quick guide and they converted it into a form, and basically for non-contingent offers. And it could either be, even if it's just the loan contingency is being waived, or the appraisal or the investigation. By the way, I have a little bug, so I apologize. If I get up and go run, get some water, bring it back. Note to self, don't go to a football game in Nashville in December in shorts. Not a good idea. Okay, next slide, please. I love this form. Now, I understand I don't keep track of California law or California politics like I used to, but I understand there's going to be some changes to California solar law. But this form is basically a twofold form. If there's solar on the property, it's a questionnaire. I'm trying to read what these people are saying. So yes, finally, it's a great form, Josephine. It's one of my favorite new ones. And basically it's a questionnaire, regarding, because again, if there's solar, as you know, it's a contingency now of the transaction that within that first 7 days, you need to provide certain information and certain documentation. And then the buyer has the 17-day period, which is actually a 10-day period if you give them everything on the 17th and the 7th day, to go through everything and to make sure that they can assume the lease, that the bank's not going to call the note, blah, 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 blah. Okay, so the first page is a questionnaire with a lot of information, an advisory of a lot of solar related information. And Josephine, I think it's a really good job. I've read it over as many times as I can, because these are those stick in the mud issues that mess up a transaction that should never be messed up. Either it can or can't be, it can't be assumed. What's this? Is there some, if there's solar, the solar advisory, it's not required. It's not required after December 19th. It's just available to you. These forms are not available today. These forms will be available in about a week and a half, a week from this coming Monday, actually. Let's go to the next page because it's really cool. The SPQ and a lot of other documents, the contract itself requires that the seller make certain representations and provide certain information, and there's your questionnaire. So why would you wait until the 6th day to get this? Why not make this part of the, and we're going to talk about disclosure later, but why not make this part of your initial package? Get it to your seller. They can be filling this out. Don't let them sign it or date it until after you have an accepted offer, to make sure there aren't any changes, so that you can always ask that, have there been any changes since you filled these forms out? That's true of the SPQ, the TDS, all that stuff. But get them to fill it out early so that it's ready to go, so you can keep these transactions moving along, because things are a little more difficult for y'all right now. All right, next slide, please. This is a form that's available. It actually came out, I believe it was in February. So this form actually is available now. And it's a designated electronic delivery address amendment. This is in case you forgot or didn't put in the correct, or someone changed their email or their text information, or you want to provide another person or an additional person in addition to whoever was on the original contract to get the notices and other electronic delivery. Because most of you now are delivering stuff electronically, and there's nothing wrong with that so long as you comply with the code of ethics. But if you initial if you provide that, or you need to make a change, this form is now available for you so that you can keep things current. Next slide, please. Now, those are the new forms. Again, not available till December 19th. Next, we're going to have the forms that they revised. And they made some revisions to the RPA. So again, I'm going to provide you with one of the changes was, and let me see if I can remember paragraph number. Hold on one second. I don't remember, I don't think I put it up. It was an oversight on my part, but if you look at paragraph 3G3, right? That would be 3G, I don't think it's up, but just to get, that's the paragraph now they've added that they will add on December 19th that says the seller is going to pay the buyer's broker. And again, there's numerous ways that can be done. Going to affect the purchase price. You can pay them a check directly through escrow. So basically we're changing something that doesn't probably happen very often. I don't know. I'm not a realtor. And I've never had a case where it's been an issue, but where the seller will pay the buyer's broker directly and contractually. This is not a violation of the Code of Ethics. Code of Ethics, Article 16, Standard Practice 16.13 says you may not use the contract to negotiate commission, right? But that's between the broker and the broker. So the brokers are making themselves parties to the transaction by renegotiating compensation. You do that on a cooperating broker compensation agreement. Here, the seller is going to pay directly. So again, I don't know if I put that up, but here's a couple of other changes. Again, buyer is going to pay up to so many points to obtain the rate above. And they've made that change in both E1 and E2. Next slide, please. I did put it up. Yay. Okay, so you can see now they've added completely a new paragraph 18. Seller agrees to contribute to the payment as an inducement to buyer to enter an agreement to purchase seller's property. And there's the form which I showed you before. So all of this starts happening on December the 19th. If it's an occupied unit, again, they've added a couple of paraphrases, phrases. Number one, it's occupied units by tenants. Sometimes the purchaser is going to occupy one of the properties, so that issue is important. Then they've added just a little attached, a tenant occupied property addendum, and CAR recommends that be used on every transaction. If occupied by tenants or others and TOPA is not attached, I can't read the whole thing, but seller shall disclose to buyer in the TOPA again. So these are changes in the RPA. And again, not going to go into any great detail. This is more for property management type issue, but I have boards and I have clients in Los Angeles. They've been going through hell. I just got an email from a client. He's a performer. He's a musician. He actually is a headliner. And he owns a house in Woodland Hills that he rents. And it has taken us the better part of 7 months to get the non-paying tenant out. And the non-paying tenant has purchased another house. So you don't have that nightmare. Fortunately, in Southeast County, you guys have a little more sane government. But if you leave, these are enormous issues. So let's go to the next slide, please. Another change. Again, if buyer intends to occupy, there's some language that you can take a look at. Just make yourself a note that anytime there is a tenant occupied property, whether it's part of the 1 to 4, or whether it's a single residential unit, you've got some very specific issues. And although most of the laws that have been affecting real estate, rental property real estate in California since the pandemic started are going to be sunsetted at the end of this month, Los Angeles has voted to extend a bunch of their stuff, and not everything is going to go away. So it is incumbent upon you to know that getting a tenant out may not necessarily be something that can be done right away. And so there's lots of negotiation that has to take place in Los Angeles now, because the only person that can evict is an owner who intends to occupy, and under most circumstances, an owner who intends to occupy. That means that the seller cannot evict. Only the buyer can after the close of escrow, and they become an owner. So that's going up in Los Angeles. We don't have that problem here in Tennessee, but many of your brethren do. Next slide, please. They've made it clear, I guess there's issues that come up, I don't know, where people argue over the associated hardware, the drapes or the rods and all that stuff that are related to window coverings. So they've made it clear now that any associated hardware, rods, things like that are part of the fixtures that are included in the purchase price. Next slide, please. Again, if you have a solar system, then they're referring to the form that I just showed you. All this becomes available in about 10 days. They've put some limitations on the contingency for buyer investigation. And the bottom line here is that all other buyer investigations not specified above, other than those specified in separate contingencies, are not limited to, it requires the availability of certain documents. So take a look at this paragraph. I'm not sure how valuable it is, but again, since 75% of litigation comes up in disclosure areas, you'll want to make sure that the buyer understands thoroughly what their rights are for investigation. Next slide, please. And Barbara or whoever is currently doing the RPA class will update all this for you. You guys foolishly use the word nominee. So just to make you feel better, under the assignment clause, they've added the word nomination. And then they have required now that if you do an assignment of a right to purchase, there's a form for that, as you know. You will also notify escrow within 1 day after the assignment, because now you have new parties that escrow needs to be aware of, because there's going to have to be some other documents that have to be signed. Next slide, please. And then they made some changes to the signature lines just to make it a little bit easier. So you can take a look at that at your leisure. Next slide, please. And I'm going to just blast through all this. They've made some changes to the buyer counteroffer to make it clear that number one, that anything that was agreed to, that isn't countered as agreed to, that if you don't initial the documents that need to be initialed, then they don't exist. And unless they're otherwise agreed, if the original offer of the appraisal contingency was for, if I'm willing to pay more than the appraised value, what this particular document is going to say is that gap will remain the same on a counteroffer. So if I'm willing to pay $25,000 more than the initial than the appraisal, which is something in the that came out last year in the 21 RPA, Then, but there was some uncertainty. So what happens if I get a counter offer for $25,000 more, right? Does that mean that I'm now paying 50,000? No, it means that the gap of 25,000 remains the same. Next slide, please. They made that change. Okay, cancellation of contract. Again, they've made some minor changes. Trying to remember what this one was. Has to do with proposed mutual cancellation. So just know that when you're canceling contracts outside of the issue of compensation, there will be some revisions to that. Next slide, please. I want to blast through this because I'm running behind here, and I know I've got a lot of questions. Next slide, please. Making a couple of changes to the extension of time addendum. First of all, they're changing the name. It's still the ETA, but it is now the extension of time amendment, because technically that's what it is. It's an amendment to the contract, and it just allows you to make a proposal that can expire just like a regular offer within a certain period of time. Next slide, please. This is a great form, by the way, to do what you need to do. The residential lease after sale. Here's the deal, is that once you go past 29 days, you're no longer in a seller in possession. You're now in a lease. And if you're in a lease, you've got to follow California law along with local ordinances. And one of those clarifies that if I'm going to rent back the property for a period of time, I can be required to pay a security deposit. But that security deposit can only be 2 times the rent. And if it's, so if the rent is $2,000 a month, then I can be required to give you a $4,000 deposit. If there's furnishings, which is rare, I would imagine, in a leaseback of a sale, it can be 3 times. And so they've made that clarification. Next slide, please. We're going to blast through these because I don't think there's too many other changes. The tenant acknowledges, again, that that whatever the terms are in the purchase agreement are also exist here in this agreement as well. And they've renumbered a couple of things because they added paragraph A. Let's move on here. Again, some modifications to the issue of smoking, to make it clear that if there's any damage caused by smoking from the close of escrow to the date that possession is turned over to the buyer or whoever, that any damages will be taken out of the security deposit. Next slide, please. No changes on page 4. Next slide, please. No changes on 5. I don't think there's any more changes if I'm mistaken. Yeah, the agency confirmation, they've added all that in the body of the document. Yeah, Joe, I understand. Love all the landlord disclosures require the buyer to be made to the seller. So I'm going to go over that a little bit with you in a minute. So next slide, please. Next slide, please. This is the move-in, move-out inspection. It is really like an Avid type form, except it's to be filled out by the residential property owner and the tenant. Okay, and I had a conversation with another lawyer. Keep this form handy, because if you get the listing, let's say I'm managing, or my company is managing this property, and all of a sudden now the owner decides to sell. This inspection is valuable to set the tone for the disclosures that have to be made down the line. You know, a lot of the disclosures, if you look at the SPQ, it's you give the new buyer everything. So it doesn't say this anywhere, but in looking at this, it occurred to myself, and I called a buddy of mine, that it looks like to us this is a document that could have some value or be a problem, depending on your point of view and the circumstances in the ultimate sale of that rental property. But as you can see, it's just a move in, move out inspection, although technically it's a revised form. As we go through it, let's go to page 2. You can see they've just completely revised it. And if you look at it, it's very similar in the way you would approach as a property manager to an Avid form, right? There's 9 pages. So let's just move through it. You can see it talks about each room. It talks about each bedroom. Next slide, please. It talks about the bathrooms, the different numbered bathrooms. Again, you can figure out how to do that. And of course, it talks about the condition as on move in and the condition on move out. So it can be used, it's a bifurcated form. It can be used in 2 different places. Next slide, please. And as you can see, it's basically it's an Avid type form for property managers now. Next slide, please. Same stuff. This is the exterior of the property. They've added safety features, keys, personal property, anything else, the sort of miscellaneous, and then there's a signature page. Next slide. And you notice there's initials on each page. So again, this sort of sets the tone, because I believe, and a lot of people believe, well, property managers right now are the second most likely people to get sued. Number 1, according to NAR insurance statistics, are dual agents. But number 2 are property managers. So anything you can do to protect yourself if you're a property manager is becoming very, very significant. Next slide, please. They made a modification to the seller counteroffer regarding the gaps and the changes in regarding percentages of the deposits and all that kind of stuff. So you can take a look at that, just a very minor change. And they did the same thing on the seller multiple counteroffer. Next slide, please. And there's the change, the identical change in the seller multiple counteroffer. Next slide, please. One more to go. Next slide, please. And now there's a revision to the property management agreement. So if you're going to be managing someone's property, this is the document for you. And as you can see, every place where they talk about landlord, it is now the property owner, residential property owner. And it talks about authority. It talks about electronic payments, tenancy termination issues, the vendor services, the broker services, all of that kind of stuff has been cleaned up a little bit. It's still the same form. It's been around for quite a long time. They've just sort of cleaned it up, and I'm going to move through it quickly. Go to page 2. So they've just cleaned up some language regarding payments and exceptions and keys and distributions, and the responsibility of the rental property owner, confirmation that they're not going to get you in trouble from a fair housing perspective, rental property representations, and references the form I just showed you, tax withholding issues and how that's going to be handled. Next slide, please. And again, you can go through this. This is a revised form. So the form that you're using today will be replaced on December 19th. By the way, we're going to be doing 2 newsletters on the new forms. I'm supposed to get one of them Monday from one of the clerks, and she's going through all the forms. And Mary Jane, you're one of the best. That'd be great. We'll talk about that when I get to the questions. So you're welcome. So bottom line, that I lost my train of thought. hearing from Mary Jane was so exciting. The bottom line being that we're going to need, there's going to need to be some updated property management programs because there's going to be a lot of changes and some new laws as well. Next slide, please. They cleaned up the attorney fee clause. And so they've clarified who the legally authorized owner is and if there's going to be any modifications, additional documents that will be bundled. And you can see there's several, the disclosure, the fair housing advisory, the consumer privacy advisory, which is changing, one of the revised forms. So you're going to be, again, property managers, you're going to be doing an awful lot of changes too, along with the agents that do residential sales. Next slide, please. Again, a signature page, including the ability, if it's an entity. So you're ready to go on that. Next slide. All right. So there's a couple of forms I didn't put up. Now that CAR is aware of what the California Consumer Privacy Act actually does, if you remember, they came out with one really long, really complicated, because no one understood the law, because with all due respect to the legislatures, it was a piece of garbage, right, in terms of how they wrote it. Now that they understand it, the new Privacy Act advisory going to be one page. Okay, so you can look it over. It's just simply a quick advisory of privacy rights, you know, because everything's going on the internet, blah, 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 blah. So, and then they made some changes to manufactured home purchases and transfers, and I know nothing about that area. Okay, they're going to sunset some forms as well, most of them being COVID related. Next slide, please. So again, these are some additional revised forms that you can take a look at. As you can tell, most of them are property management forms, and most of the sunsetted forms are property management forms as well. So let's look at those for just a second. All of these forms go away on December 19th. I guess the pandemic is over. But they can be brought back. So let's go to the next slide, please. All right. So I say I have 17 questions. I will get to them. I want you guys to stick around. And the reason I do is because there's a lot of important information that I have an hour to get through. Probably going to go over a little bit today. Hopefully y'all can stick around. It's Friday, so what else you got to do? Okay, so here's the deal. So Lisa Force is representing a buyer. And Lisa Force shows the potential buyer the property that they ultimately purchase, because if they don't purchase the property, probably not going to be a lot to argue about. Now, Terry Ryan ends up getting that buyer from Lisa somehow, and he closes the deal. Now, under current rules, the rule at the MLS is not that complicated. The offer of compensation that currently exists in the MLS is offered to an agent, a subscriber, and or a participant who brings in a buyer. That's called procuring costs. Now, for those of you that are on the procuring or that are on the professional standards, either grievance, the board of directors, or hearing officers, we're going to take a really deep dive into this in February. I don't know if Linda sent out the save the date, but I'm going to come up with as complicated a hypothetical as I can. And we're going to really talk about this because they're changing the procuring cause guidelines effective December 19th. What is the procuring cause guidelines? It's a list of about 25 factors. So here's what's going to happen. Lisa thinks she's entitled to the $1 million 2% commission. And of course, Terry thinks he's entitled to it. And neither one can agree. They won't mediate or they can't settle. So now under both the MLS rules and under Article 17 of the Code of Ethics, they're required to go to the board to settle that dispute. And we hear a bunch of them every year. We just settled one the other day, not in Southwest, for a little over $400,000 commission. We did one a couple of years ago that went all the way to hearing and beyond, and it was $960,000. Now, obviously, most commission disputes aren't that big, but heck, this is your livelihood. This is a lot of money. And Lisa needs it for her vacations, and Terry needs it for his, and so got to get that money. So the hearing panel is going to have these factors, and it's not a scorecard. It could be one factor, it could be the factor, right? It could be several factors. It could be a whole number of issues. They're broken up into different categories. And so they've made some pretty significant changes, and I want you to know about it. Number one is, and this is the only one I'm really going to emphasize. The others are relatively minor. We'll talk about them in February with the hearing officers. But basically, they have said, look, if you have a buyer representation broker compensation agreement, the BRBC, if you have that, that's going to be not the deciding factor, right? Not the critical factor, but a much more important factor to consider if you're going to earn a commission, right? So let's say Lisa had the foresight to get a buyer broker representation agreement that is non-exclusive, okay? Now, that's going to create in the minds of the hearing officers, now we have a contractual question, right? Now Lisa's taken the time, or Michelle, or whoever it is. I got some really cool people here today. They've taken the time to put this in writing. And so they're going to be giving, and I'm going to go over it. We're going to, once I hear from the panel, probably in late February, I'll write a newsletter because I want to hear what they think. It's not about what I think, it's what they think, right? We're going to do this at Pacific West, Tri-Counties, Citrus, Southwest Riverside, Downey. So quite a large contingent of your people in the areas where you would practice. Not all at once, going to do it over a 1-week period. And we're going to look at, what kind of a BRBC agreement was it? Was it non-exclusive? Okay. Then how does it fit in to these other factors? And it does affect about 4 other factors. Okay, so it isn't just this one factor. It also bleeds into about 4 other factors. Is it exclusive? Lisa got an exclusive. Well, now guess what, Terry? When you ask, are you working with anyone else? And they say, yes, we've been working with Lisa, and you call Lisa, or they tell you, yeah, we signed an exclusive agreement. You got to stop. Because Article 16 of the Code of Ethics says you shall take no action to interfere with the exclusive representation or exclusive agency of another real estate professional. Period, end of story. So not only are you not going to want to work with that person because you can't, because somebody else has the contract, but number 2, you might actually get called up on ethics charges and have to pay a big fine. So don't do that. Also, was the property described? Did Lisa actually show the property that Mr. and Mrs. Buyer purchased? What kind of weight are we going to give it? Again, it's not a scorecard. NAR does not allow us to say, if somebody does this, they win. But they're going to want to know, and I'm going to find out, because we're going to spend at least an hour talking about this and what do they think this means I'm going to send it all to them probably in late January. I'm already outlining the form or the material. I've got the PowerPoint almost done, and we're going to sit down, or I'll be standing, they'll be sitting, and we're going to have an adult conversation about what all this means. And so go to the next slide, please. So again, I'm writing up a new class. I don't know if I'll offer it at Southwest. I'm doing it for another board with a broker up there. And we don't have a title for the class yet, but it's basically going to be called something like Broker Representations Getting Paid in 2023. Because I believe that if you don't have a buyer representation agreement, you got civil liability issues, proof of what was said and what was provided. You've got potential exposure to not getting paid. There's a lot of stuff going on that could be a problem for you. And I think, and we're not to the MLS yet, but I think when you see all of this, you're going to realize you're in a transitory stage right now as it applies to buyers and buyer representation. Okay. And there's nothing wrong with that. I sold my house in Canyon Lake, right? And I'm your friend. I've been your lawyer for a long time. I never sue realtors. I'm a good guy. But I still was shocked at the amount of money that I had to pay for to sell my house in terms of the commissions that were paid. And I think when you look at what I'll talk about in a second, that's at the heart of a lot of this, right? That's at the heart of a lot of this. So a couple of changes to the Code of Ethics, nothing really spectacular. Article 3, which is the duty to cooperate, Standard Practice 3-9 sets the tone for how a buyer's agent is allowed to show property. And they're allowed to show property only as the owner and currently the listing agent provide. They're deleting the term listing agent. So it will now read that realtors shall not provide access to listed property on terms other than those established by the owner or, yes, Susan, I did, because you keep telling me the same thing, or the seller. So bottom line, it will reflect exactly what Article 1, Standard Practice 1-16 says. They're changing a word in Article 10. Article 10 is the do not discriminate article. And Article 10 currently has the word handicap as one of the 9 categories. They're changing the word to disability. It's not going to impact you in too much, but they're changing that word because it sounds better, frankly. Next slide, please. That's effective January 1st, by the way, both of these. Also on January 1st, this doesn't affect anybody that's here today, but if you're a really bad guy, right? If you're just a really bad guy and you commit an egregious violation, you steal from a client, you discriminate because somebody happens to be of a certain color or creed, right? You misrepresent a client in such a fashion that they become substantially financially damaged. We're going to expedite those hearings and get you some justice as quickly as we can. So I think that's going to be a good change. It really doesn't affect any of you. Just want you to be aware that the bad guys are going to be put in the fast lane. The phrase, the Article 15 of the Code of Ethics currently says that you will not discriminate, that you will not disparage, in other words, make a knowingly false or misleading statement about another real estate professional. But they never defined what a real estate professional was. So what they did is they said, we're going to define it as is defined in Article 11. So put up the next slide and I'll show you. Don't say anything bad, false or inappropriate about people that practice in residential real estate brokerage, real property management, commercial or industrial land, real estate appraisal. Move on, please. Next slide. real estate counseling, real estate syndication, auction, or international. So that's it. Don't say bad things about those people, or you might be brought up on charges. Next slide, please. So what's going on with the MLS that's brought all of this to a head? There are currently class actions pending, and I'm going to simplify the estimated damages if NAR loses these cases is about $5 to $6 billion. Billion. Okay. So when I say I'm simplifying, I'm just going to the core. Here's the deal. When I listed my house in Canyon Lake for sale, I agreed to pay my realtor a percentage of the sale price of the house. She then put it in the multiple listing service and offered 50% of that amount to a buyer's agent to bring me a buyer. According to the plaintiffs, what just happened was I paid a big chunk of money to another agent who did not represent me, was not a fiduciary to me, and was in fact negotiating against me. That is the thrust of the argument, that NAR's rule of mandatory compensation artificially increases the cost to sellers for selling a house. There is a case in Missouri, it is called Spitzer. In the Spitzer case, the court has certified all sellers who have sold property since April of 2015 as being part of that class. That means that approximately half of the commissions are now part of a lawsuit against NAR and a bunch of brokerages in the state of Missouri under federal law. And that case will go to trial in late February with a 6-week estimated trial date and an estimated decision sometime in the middle of next year. If NAR wins, yay, yay. If NAR loses, we expect to see copycat lawsuits all over the country. There's a much, 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 much bigger case pending in Illinois. Basically the same allegations, right? That case has not yet been set for trial. There are motions in all of these cases, very, very complicated. Motions are currently pending in Missouri, motions are pending in Illinois, but the Illinois case is multiple listing services, multiple brokerages, and of course, NAR. That case is worth an estimated $4 billion if the class is certified and if the defendants lose. Okay. Additionally, the buyers got in the action. The buyers said, well, wait a minute. The sellers didn't get damaged. I did, because I had to pay more for my house because I had to pay the seller's commission. And the judge dismissed that case, but she allowed them to amend. And now that case is back and they're arguing it all over again. But here's why it's important. If she doesn't dismiss, the defendants, or the plaintiffs have alleged that there is 25 states that are also committing antitrust violations. And one of those states is, you guessed it, California, right? So we are monitoring those cases very, very closely. Now, what happens if NAR wins everything? Which frankly, they very well might. They've got good, solid arguments. A lot of this stuff is hocus pocus. But what if they win everything? The Federal Trade Commission under President Biden is investigating organized real estate as well. The Cato Institute, and I have all the stuff if anybody's interested. The Cato Institute, which is one of these big think tanks, wrote an article some years back arguing that real estate compensation is artificially inflated because of the way the industry is structured. Now, why is that important? Well, because President Biden's member of his cabinet is one of the people that authored that and is part of the Cato Institute. So President Biden has ordered a bunch of his departments, particularly the Federal Trade Commission, to look at organized real estate. And the scuttlebutt is that the FT is waiting to see what happens to these lawsuits. So again, as you can imagine, there are all sorts of concepts being thrown around. Frankly, it's what I've been doing lately. A lot of what I've been doing lately is dealing with these kinds of issues because, we don't know what the changes are going to look like. The Department of Justice has gotten involved. Now, up in the Northwest, as I mentioned before in Seattle, it's a broker-owned MLS, and they're looking at doing some direct, where it's not the brokers that get involved, it's the seller directly with the buyer and the buyer's agent. Another issue totally unrelated. So I talked to Jeff Smetana the other day, as I do often. He's the attorney at CRMLS that's in charge of citations. Jeff and I don't agree a lot about a lot of stuff. He's a great lawyer, nice guy, lives in Knoxville also. But he was telling, because Linda, my paralegal, brought to my attention that a lot of, right now what the rule is if I'm a broker or if I'm an agent and I get a 4th citation in a calendar year, I've got to go to the grievance committee at the board that I am part of and explain to them why I'm not committing an ethical violation. Well, you don't get too many agents that get 4 a year, right? But what happens if I have 100 agents or 185 agents? It's very likely that I'll get more than 3 citations, because remember, these are my listings as the broker. So if I get more than 3 citations in a given year, that 4th citation now goes to grievance unless the violation is corrected. Now, some violations like the photograph violation can't be corrected. So let's say I'm Mary Jones and I've got 200 agents and 4 agents don't bother to correct an MLS violation. I'm going now to go to my board and I've got to now explain ethically why this is happening. And we have a few of those and they're in my boards, and we're trying to figure out what's fair, because a lot of times the agent doesn't pay attention or the broker doesn't pay attention to that. And so we're trying to figure out how to help those brokers, because again, this isn't a vigilante committee. So film at 11 on that one, but be aware that you need to tell your agents if they get an MLS citation, they either need to fix it or bring it to your attention, because this can get you in trouble as well. Good question, Corey. I don't know. I'm not a broker. I make a lot of money off of brokers that don't fix things, so I can't explain it. So I want to run. We're going to send you guys a newsletter probably next week. The number one claim at the Department of Fair Housing is disability. Disability, right? Not race, not ethnicity, none of that stuff. It is disability. And it comes up in 2 ways. One, it's a fair housing violation, or number 2, it's an ADA Disability Act violation. And the big ticket right now is websites. And we're doing a newsletter, going to send it out to y'all. I got to edit it, sitting in this big pile over here, but it's at the top of the pile. Some of you might have gotten a letter from a gentleman named Wong. Don't send him any money. Let the board know, or let me know. We've been dealing with Mr. Wong. Nobody's going to send him any money, but he's been writing well over 1,000 letters all over Southern California to realtors saying, I was going to use your services, but I went on your website and it's not compliant with the Americans with Disability Act. Send me, I think it's $14,000. Don't send him a dime. But again, That's Mr. Wong. And you get letters like that all the time. People get letters like that all the time. The real issue though is your website compliant? And if it is not, then you need to figure out how to fix it. CAR has a quick guide on website compliance. You may want to take a look at. Next slide, please. Again, there's a lot of new laws. You guys got more new laws than we actually had bills before our legislature here. You had 1,200 new laws. So there's a couple of laws. If you're going to try and get a broker's license, there's AB 2745 has clarified that a little bit. If you have had drug convictions and want to go to work for an escrow company, they've made some changes to the licensing law there. They've restricted the ability of HOAs to restrict rentals. This doesn't affect short-term rentals, but a lot of HOAs try and restrict rentals. And so 1480 will further restrict that. They've restricted the ability to prevent accessory buildings from being built. And there's a new law that will ban bundled sales to like a REIT or something like that. And that's to allow more properties to be available, generally speaking, on a singular basis. So there's a Q&A that came out. It's all the new laws. You can take a look at that. I don't think there is, go ahead, the next slide. There's something more significant I want to talk about. And I want to get to these 27 questions. Holy gosh. There's going to be a new law. You know, if I'm a tenant, sometimes I have to, go to 7 or 8 places to find a place, maybe more. I don't know. I'm not a renter, but I've got to pay a screening fee. There is going to be a new law, AB 2559, that will allow a tenant to request that a screening report, if it's a certain type in a certain manner and reliable, to be used for a certain period of time to save them some money. I actually have this case right now. Under current California law, if I am a tenant and I am the victim of domestic violence, there are very specific ways I can get out of my lease. I have a case right now where each tenant has her own lease. One of the 2 tenants is being severely sexually harassed, and under the current law, and their 1017 will expand the law. The landlord has to allow me to terminate that lease, even if I've got a period of time to go, and I'm not liable for damages for re-rental or unpaid rent. And then they've further made it difficult to collect debt by reducing the amount that you can get from wage garnishment. So there's going to be a lot of landlords or residential property owners. We're going to go to small claims court and get judgments against tenants who didn't pay rent. And now it's going to be even more difficult for them to collect on a wage garnishment because the percentage of the person's pay is being limited further. I think it was 25%. It's going to be limited. I don't remember the amount, but it's less than that. Next slide, please. You're going to have to start taking implied bias training. If you're renewing after January 1st, you're going to have to show, and I don't know if they've even come out with those yet. I got a feeling we're going to hear from the DRE that they're extending the time period to July 1st, because I haven't seen anything from the DRE on what those implied bias training classes are going to look like. I met with your chief lobbyist when I was at that meeting in LA, and these things were beaten back this year, but it's no longer an election year. You have a super majority, and he expects the taxes, local and or statewide, on vacant land to be brought back. And as you probably know, in San Francisco and Santa Monica, I have to offer my property to my tenant first before I can sell it. Go back real quick. Before I can sell it. And that law was proposed for California statewide. It was beaten back by CAR and others, but we fully expect it to come back again. So just be aware. If you get a red alert, respond to it. These are important issues. Next slide, please. There's a new cases, but most of them are, there's not really a lot directly related yet. We're waiting on about 5 or 6 cases, but right now, if you get a commission under false pretenses, a Siri investment sued for commissions, and those false pretenses were alleged, you're not getting the money. So, but one of the claims I suspect that the plaintiff lawyers will start raising is that you misled the client. Now, do I think having a buyer broker representation agreement would be helpful? Yeah, probably, because everything's in writing. 2710 Sutter Ventures, an LA case. And in that case, the company commenced a bunch of foreclosures. They didn't follow all the highly technical rules. Those of you that do property management know that every I needs to be dotted and every T needs to be crossed. They didn't, and none of the evictions were allowed to go forward unless all of the ordinances are complied with. And Cameron, I thought was interesting because Cameron was suing, the family was suing the property owner's company because they were harassing their tenants and allegedly trying to evict tenants wholesale. Ms. Cameron is an elderly person, and in addition to winning the eviction case, she also won on an elder abuse claim. So again, we'll do a little more writing on these, and next time I do a brown bag, I think I'm doing one in March. I'll dive a little bit deeper. Oh, thank you, Pauline. Our new president, Madam Boss, said March 3rd, and I don't remember the time, but check your local listings and they'll tell you. Next slide, please. Okay, a couple of real quick things. At the meeting in LA, and then yesterday, Steve made a comment, and I'd really like to hopefully get him out to our board because he's just a fabulous lawyer, one of my favorite people, and he does insurance. Probably one of the top attorneys in the state, if not the top. And he said you can fully expect, and this is not good news, I'm sorry to bring it to you, that you can fully expect that you're going to start seeing either an increase in your premiums, or you're going to see significant increases in your deductibles. And at the meeting, besides people like me and Steve, a bunch of the in-house attorneys were there, and they were saying that they were already raising their deductibles very significantly, $25,000, $50,000, because they just can't afford premiums otherwise. Do not calls is coming back. We're seeing a lot more claims now. So if you're using one of these robocalling services, be very careful. Remember, there's a do not call and also a do not text. Sitting open houses for other agents. So I'm a member of Lisa's company, and I want to sit an open house for John. I talked to Steve Lerner, who's in charge of legal at DRE, and it's not against the law, but he strongly recommends you don't do it because there's a lot of issues dealing with the two brokers, with indemnifying the seller, all kinds of stuff. So be very careful about that. There's a case that came down. Basically what happens is I'm a buyer. I put down a 3% deposit, which was $72,000. We went into escrow. Within a day or two before I got started with all my due diligence. I saw a house I liked much better. So I went to my agent and I say, I want to get out of that transaction because I've got something I like better. They cancel. Of course, all their contingencies were still in effect. And the seller said, wait a minute. And he talked to his lawyer. And the lawyer said, well, did they act in good faith? Well, they never applied for the loan. They didn't do anything they were supposed to do. Now, the facts of the case were limited. I will agree, but I'm going to make a point, and the point is this. The court agreed with the seller, said, you didn't do anything to act in good faith, right? You just having a contingency isn't all there is. Under contract law in California, you've got to act in good faith. You didn't act in good faith. So they awarded the entire deposit to the seller, along with another about $30,000 in attorney's fees. And the testimony of the buyer was, well, my broker told me I would get my deposit back. Don't do that. Do not let your agents do that. It is not a good idea, because if they're wrong and the client says, well, I'm relying on my broker to provide me with good legal advice, well, you all know that's a no-no, so don't do that. This is something I just was talking to a couple of my broker clients about, and want to just to bring to your attention. Properties were flying off the market or off the shelf last year, weren't they? Suddenly they're not. So be a little more cautious. If you have a sale of a buyer's property contingency, be thinking about how that's going to look in this market where that property may not fly off the shelf as quickly, and how's that going to impact your transaction, your negotiations, and all that. The DRE is telling us that they're really looking much closer. So tell your broker, unless you are the broker, that they're looking much more closely at broker supervision every step of the way, particularly now with all this buyer stuff and everything else. Broker supervision, fair housing, all this other stuff. Brokers, you got to supervise. They're looking at fair housing much more closely. They're looking at just a wide panorama of issues. They're ramping stuff up. And so be very, very careful, especially property managers with your audits. It's going to cost you a lot of money if you get audited and they find something wrong. A couple of things that came out of yesterday. Let me find my notes, because I took some notes yesterday. We talked about that. So one of the questions that came up yesterday, and you guys may be asking it, I haven't looked at any of these 29 questions, but when do I ask for a buyer broker representation agreement? Probably before you start showing these people property. If you're going to show them property, get a buyer representation agreement, at least the one for no money. I think that was the consensus of everybody yesterday. And then when you're looking at disclosure issues, which really, the whole issues of disclosures and all that, think about things in terms of, look at it 3 different ways. Number one, your marketing. Give yourself wiggle room, because if you say something that is incorrect, this is the best, this is the largest, if you that EST, if you use some kind of a conclusive type of a statement, it may come back to bite you. So be very, very careful about how you market, because plaintiffs' lawyers are, according to the insurance lawyer, are using marketing materials more than ever before. 70% of lawsuits arise in the area of disclosure. If you don't write it, it will harm you unless it's good for you, in which case it will never be brought up. So write it and make sure that it's clear what these disclosures are. And again, I'll probably do a disclosure class next year. I don't know if I'll do it at your board, but if not, I'll give it to somebody who can. Because there's really a very set way of doing that. And then lastly, write it. Because if you didn't write it, it didn't happen, right? Let's say you don't have a buyer broker. You didn't confirm some kind of a conversation. In other words, you just didn't have a very good file. I think you're going to be in a world of hurt. Document stuff. Document it as best as you can. And again, get all your disclosures, all that stuff done as early as you can, but don't date it. So you can always have the ability to ask before you transmit it after you get it signed and dated. Have there been any changes? Maybe you did this TDS a month ago, right? Maybe you did your Avid a month ago. Ask your client, are there any changes? Then have them sign it and then have them date it. All right, let us start looking at some of the, go ahead to the next slide. I think that was it. Yep, that's our blatant commercial. So let me jump into these these questions. I'm going to start, and some of them are comments, some of them are questions, but let me go to the top. All right. Can you get the forms larger? Hi, Barbara. I don't know. You can zoom in, so that's not a question. I noticed
Hey,
that.
John.
Yeah.
Couple of questions came to me directly, I guess. This one came from Jennifer. A commission can be paid to a buyer agent from both seller and buyer, correct? That was a question.
As long as everything's disclosed and everybody's aware, yeah. In other words, if you look at the new form, it says all or a portion. In other words, it doesn't anticipate that the seller's going to pay the buyer's broker all of the money. It could come from a couple of sources. Maybe your agreement is that you will be paid at least 2.5%. And I'm only willing as the seller to pay you 2%. So the other 0.5% would come from the buyer. So it just depends on the circumstances. These are the things everyone's going to need to relearn. It's a good question. Let me answer these and then I'll finish with the ones that you have, okay? Because these people put them up quite a while ago. I noticed that some of these forms just have a signature line, but no line for a name to be printed under the signature. Yeah, that's true. Just going to have to write legibly. But if you use DocuSign, it'll always be the same. Some form, and this comes up all the time. Some forms have initials, some do. I've never really understood, and I've never frankly got an answer that I would share with you as to why they do that. Joe mentioned many of the drafts. Yeah, they're still looking at them. In fact, we raised some issues at the meeting a couple of weeks ago about the changes to the independent contractor agreements that they're working on. So we may see a few more. How will this affect the loan portion for FHAB? I'm not sure what this was, Kelly. So maybe you could, drop me a little note or give me a call. You have my number. Because I'm not really sure what we were talking about at the time. Do we have a grace period before we start using these forms? No. When they go live, as I understand it, and remember, I'm not a realtor, but as I understand it, and Joe or any of the others, you can correct me. If December 19th is the day, you're going to wake up in the morning, turn on your computer, and on December 19th, all the new forms will be available, and all the revised forms will have replaced all of the current forms on that date in Zippy. So that's my understanding of how it works. Love all the landlord disclosures required of the buyer to be made by the seller on this side. Yeah, well, it makes sense. I mean, the bottom line is that, it's kind of funny. I've got to give the seller, who is now the tenant, a bunch of disclosures on a house they've lived in for 5 years, but it is what it is. So I am a CAR certified trainer, not surprised. I have this class. Well, I know what this class is ready for live or on Zoom broker agents team. Feel free to reach out and have You schedule, what class, let me know what class you're talking about, Mary, because I'm not really sure what class you have available, but I'm sure it's a great class. If it's a property management class, I would jump on that class sooner than later. So again, I don't know what class you are offering. Let's see here. Did a lawyer just comment on the money we make? Yeah, I did. You guys comment on the money lawyers make all the time. So why aren't we allowed? I was a consumer. Last year, I was a consumer 5 times. I sold 2 things and I bought 3 things. And, I paid a lot of money in commissions, and I have a right to question that. And frankly, I thought most of it was pretty fair. But when you start getting into the high dollar numbers, how do you justify, I'll just pick a number, $50,000 for 10 hours, 15, 20, 30, 40 hours. If you're looking at a $500 an hour, that's 100 hours, right? Or 50 hours. So again, that's what people are arguing about. I'm not saying they're right. I never whined about the amount I paid, but people are looking at the amounts. And as numbers go up, particularly $900,000 commission on the buyer's side alone. Really? Seller agrees to pay the listing agent, and the listing agent then makes a help wanted MLS. Well, here's the thing, Joan, I'm not really sure what you're saying there, but here's what's probably going to happen. What's under attack is the mandatory requirement that compensation be offered. Okay, so what Ed's working on are different kinds of rules. You can put in there that the seller will pay a buyer's broker. You can put in there that all kinds of different things. We don't exactly know. We're probably probably at this time next year, this brown bag, if I'm still doing it, if I'm still invited, this brown bag will probably be talking about the new methodologies being suggested for compensation. I'm guessing at your board's retreat in January, the first week in January, there'll be discussions about this. It'll be a topic. What kind of bid models, what happens with listing aid, what happens with buyers who don't have the ability to hire someone and pay cash? What about is there going to be more dual agency, which is not necessarily good for consumers? What about what new business models will be out there so that people can say, you know what, everybody expects to pay compensation, right? And it's expensive, but if you do a good job, and you've heard me say this, those of you that attend my classes, you are worth your weight in gold, right? I'm a real estate lawyer. I've been one for 40 some odd years. I didn't have a thing to do with the sale of my house. I didn't even prepare the disclosures, nothing, right? My realtor did all that stuff with my wife, and they did a great job, I hope. Why doesn't the broker fix it themselves? Corey, what's it? I'm not sure. Oh, you were talking about the MLS citations. Sometimes they're just too big. They don't have the ability, or they don't check everything. Somebody checks their email for them and doesn't take it seriously, or the agent says they'll take care of it. It's a lot of different reasons. So it's just something you've got to deal with. I don't think it's fair exactly the way it's going on, and we are negotiating on your behalf to try and see what we can do. Jeff and I are going to talk on Monday. I've sent him over the specimen cases that I think are unfair, and film at 11. We'll keep you posted. Hopefully it'll work. Save the date, March 3rd. That's the next brown bag, and I don't know what I'm going to be talking about, but it's 3 months away, and there's going to be lots of stuff done. Why didn't they change the memo? I don't know. They thought that property manager people thought that needed to be changed. They lined it up with other inspection forms, so everything sort of links together, at least hopefully. Oh, okay. CR form. Because I don't have the time, and frankly, people like you and Barbara and Pauline and Michelle, You guys use these forums all the time. And so, I only hear what I hear and what other lawyers, what lawyers tell me and what I tell other lawyers. And I read these things and I go, what if? So, we'll see. When is the red line version of the new and revised forms? They're available in draft now, Barbara. So you can go on to CAR and you can look at the forms. They're available there. There's a matrix with a summary. All of that's available to you. I get them directly because I'm a cool guy and I'm a lawyer. But you guys can get them. Their CAR has all this stuff online right now. Oh, and Pauline shared the link with Barbara. Thank you, Pauline. You should co-host this class with me. So anyway, there's a lot going on out there, kids. And the good news for you guys is, as members of Southwest, you guys have, there's very few boards that provide the level of education that you do. It's not all about parties and, barbecues and all that. There's a lot of tough stuff. When you become a professional, I said this we did an orientation last week for your new members, the ones that are going to get you in trouble because they don't know anything yet. But when you become a professional, whether it's being a doctor, a lawyer, a realtor, a dentist, whatever it is, when you become a professional, you've agreed to a lifetime of learning, period. You're always reading, you're always learning, you're always morphing, you're always, looking for new opportunities. And I believe right now, between all of what's going on and all of what might happen and everything else, it's probably the most very difficult time for realtors. But I will pledge that as long as I got breath, we're going to do what we can. There's another lawyer in the vicinity that I work with, and he is a young lawyer. I will say learning, but he's learning fast, who probably will eventually, take over for me at some juncture, because we all have a shelf life, right? I found out that this is not blonde. And so, we'll keep going. This board is dedicated to making sure its membership knows what's happening. So I don't know if there's any other question. Oh, I'm sorry. You had a couple of questions that came in. I forgot. Before I sign off, I will answer those questions. I want to make sure every one of you, again, we're allowed to say this in Tennessee. So I wish you a blessed Christmas and a prosperous New Year. We had our tree lighting last week, and we had Christian singers, not allowed necessarily in some places in California. So it's a little different here, but I really wish you and your families a blessed holiday season. It's going to be fine. We're going to get through all this. Country's in a lot of trouble, a lot of things going on right now. So hopefully we'll see our way through it. Go ahead with the last few questions, and I'll do my best.
This one came from Roberta. How far in advance of the actual purchase should you have this signed? I'm working with the buyer in New York that will not actually be buying until May. However, I am sending all sorts of information on a regular basis.
Well, if they're not going to buy, they're just simply looking. They may be using you for a lot of information you're never going to get paid for. One of the things we're looking at is, should there be a way to charge for non-agent related services? Should you be able to do things that you're not going to get, that today you don't get paid for? But there really is no rule on when. It's when do you feel comfortable, and because you're going to be, again, helping them. But I imagine if they're coming from New York, they're planning on spending a lot of money, and just, ingratiate yourself. Here's the deal. A lot of times it's the way you say something, right? Treat it as a service. I'm servicing you, Mr. New York, and therefore I'm going to provide you with a document that's going to tell you everything, the things I intend to do, what I'm not going to do, how I expect to be paid. Right? Wouldn't you want that of your lawyer? Don't you want to know if you're self-insured? how your doctor's gonna charge you. What's wrong with that? But I can't answer how far in advance. I don't think there's anything wrong with giving it to them now, but, you know, so that you can start marking those broker involved properties, but I don't know the extent of what you're actually doing for him. But when they start getting real, when they start getting ready to kick the tires, no later than then, for sure. Any other questions?
Barbara said, John, do you recommend we use the ESD for vacant land disclosures? Is the environmental survey reference in the VLPA a specific
I don't
survey
remember all the
already?
numbers, but if there's a form and you think that you know, it's gonna provide, I don't remember which ones those are, to be perfectly honest, but if there's a form that you think can help you and provides you with some, and your client with some information that might be valuable, what's wrong with using the form? I mean, these forms were written by top-notch lawyers for your benefit. Are they perfect? Of course not. But these are very, very fine lawyers. And I would, you know, wherever possible, use them. But Barbara, if it's Barbara Haran, she can call me. Right? Barbara has my home number.
And this last one from a Sunil.
It's not Barbara Haran.
No.
Oh, it's not. Okay, well then the other Barbara, send me an email. I don't know who you are. My email, by the way, guys, if you have a question or you're driving home, or damn, I wish I would have asked him that. JVG at Tyler Birch, and the Tyler Birch is on the PowerPoint. Okay, one last question.
Yeah, the last one is, so if we have an inspection contingency and cancel after inspection, what reasons are reasonable?
That's a great question, and the answer is it depends on the circumstances, but you don't really need to give a reason necessarily. You just need to have acted in good faith to satisfy yourself whether the contingency should be removed or not. What happened in the case I talked about is the court felt all you really did was try and tie up property while you were looking for other property, right? But if you've made application for the loan, if you've ordered up the inspections and started getting them ready to go, if you've done the things in an expeditious manner, and you're down the line the way that question was posed, you're going to be fine. I'm pretty sure. Here's my thing. I represent realtors for the most part, probably 75% of my practice. I don't want realtors giving legal advice. Oh, don't worry about it. The deposit is going to be yours. I just think that's a bad idea to give legal advice. You know, what you can tell them is, you know, but you put it in writing so there's no misunderstanding. In my opinion, you should get back the deposit, but these are legal issues, and I strongly recommend you speak to an attorney and get a legal opinion. I just don't think realtors should be doing that. Not, you know, some realtors may disagree with me. Go ahead. I got a cruise to pay for, so go ahead. You know, if you want to expose yourself to liability, but I just think it's a bad idea. Any other questions?
Not from the chat.
Okay, then I think we are good to go. There's a lot of other stuff going on, kids. But I think I just highlighted as best I could what was happening, what I'm hoping to be able to do, but obviously it'll be up to Pauline and her board. I'd like to do at least one or two legal panels next year. I'd like to bring in the MLS attorney. I'd like to bring in somebody that's familiar with this kind of stuff, maybe even a broker, you know, that's familiar. Joe, if you sat on the panel, maybe somebody like Joe. I'd like to bring in some speakers on the hot button issues, whatever they might be at the time. And we've been very blessed to be able to do that. We've had a couple of well-attended panels. I'm also going to do a couple of brown bags. I don't know how many, at least two, maybe more, maybe three. And then whatever classes I'm going to do a buyer broker compensation class. I'm about halfway through it. But I probably won't finish it till the beginning of the year. Oh, one last thing. I'm revising the advertising guidelines. I should have that out. Cody Bellmeyer and I wrote it. I'm updating it because it's been a year or two, and we'll provide that. That's going to be something I'm giving you guys for free. Did I say that? Did a lawyer say free? I can't believe it. Anyway, you guys take care. Yvonne, thank you. Say hi to your hubby. I'm glad what happened yesterday. The Raiders deserve to lose that game. So we will we will talk to all of you soon. Have a wonderful Christmas holiday. And to the board members that are in attendance today, I will see you on January the 5th live.